Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. All right, Harvey Adelson, you in danger, guy. I know this video is about Donna Adelson, but Harvey is implicated so much to the point that I think he may be next. I mean, if he lives, God willing, because I think they're going to need Wendy to testify against him. And then she'll be last. And with all of her family, well, not Dr. Rob Adelson, not Ben Franklin, but the rest of her co conspirators in prison, it's going to be hard for the jury not to convict her, right? And how will they know? Because they'll have all of them, Harvey, Charlie, Donna, will be traipsed out in their prison blues and those fancy bracelets right in front of the jury of Wendy's trial. You heard it here first. Those are my 2 cents. All right, we're going to talk about Donna's appeal and these wiretaps, trap and trace, all of that. But first, we're going to thank the members and everybody who supports me buying me a coffee. Thank you for just being here. But that is your cue that I'm going to roll the intro. And I will see you on the other side. Alrighty, so at the heart and soul of this video is Donna is trying to have Judge Everett recuse himself. So she filed 2 motions on that, the original motion and then an amended motion. I'm not going to go over those because I think it's pretty basic of what that means. And Judge Everett came back with this denial that you see on your screen. No. Order denying defendant's amended motion to disqualify the Honorable Judge Stephen Everett. I tripped on this. He pronounces it Stephen, right? The other one pronounces it Stephen. Anyway, Stephen Everett. This cause came before the court on defendant's motion filed on April 14th and entitled Defendant's Amended Motion to Disqualify the Honorable Judge. The motion is legally insufficient and therefore denied. And that was the very next day. They filed it on the 14th, done and ordered on the 15th. He wasted no time. He sent it to all of the attorneys involved. Were they satisfied with that? No, ma'am. They were not. So they went right on over to the First District Court of Appeals and they filed something there. I'm not going to cover that. I'm going to cover the denial because I think that's where the meat and bones of it is. I will cover their most recent filing that was unsealed. And thank you to Judy from AA Legal Focus for sharing the unsealed one, which is the next document. So petition for writ of prohibition. This is the Justice J. Long that wrote this out. But most importantly, she argues, Donna Adelson argues the trial judge should have recused himself based on her amended motion to disqualify. I just read to you that he did not. She claims that the trial judge engaged in improper ex parte communications with the state by reviewing search and seizure warrant applications. The warrant applications involve Adelson's husband's phone records. Harvey, you in danger, guy. And a wiretap of his cell phone. Adelson claims that because the warrants relate in part to her and her criminal prosecution, the judge's review of these warrant applications constituted ex parte communications and has given her a reasonable fear that she will not receive a fair and impartial trial. So in that, there were no specifics about what her stuttering here, what her fear was based on, right? It's not uncommon for the sitting judge to have signed an ex parte warrant. It's ex parte because we don't want to give you a heads up. If we tell you we're going to wiretap your phone, you're going to change your pattern, and we're not going to capture what we believe is happening. So it's not unusual. He signed her the affidavit, her before she went to the grand jury, like all of those documents. The day she got arrested, he signed it. Remember, we heard who was it, Sanford? It may not be Sanford, but how they were rushing that day. They had to go up there, get the warrant up. Well, they were in Tallahassee. They had to get the warrant up there to the court from Judge Everett signed. And then they traveled all the way down to Miami to catch her on the jetway. So it's not, and did that make her fearful? Like, why now? Do you know? So we're looking for that specificity about what has changed in this. Why is this out of the norm? Because it's kind of business as usual. So the appellate panel, there's 3 of them, acknowledge that it is routine for child judges to review warrant applications and then preside over the resulting criminal trials. He did that in Charlie's case. Trial judges are commonly issue arrest and search warrants for criminal defendants that have pending cases before them. Adelson's petition amounts to an attack on this common practice. So if they grant it, then they're setting precedent that this is okay. So they need some extenuating circumstances. Like, why is this case different? And then they go through what the standard is, general prohibition, like why you can't normally do an ex parte communication, which is one party talking to the judge without the other party present, right? So the code of conduct contemplates this and permits a judge to initiate or consider any ex parte communication when expressly authorized by law to do so. So they're saying, yeah, this is normal. What is she talking about? We're not changing anything. I copied and pasted this. That's why I didn't put my watermark on it. So it's a little wonky. So, and with respect to wiretapping in particular, upon such application, the judge may enter an ex parte order as requested or as modified, authorizing or approving interception of wire, oral, or electronic communications, those emails, social media. In short, the ex parte communication in this case were expressly authorized by law. The ex parte communications in this case were expressly authorized by law. And it's this section of the Florida statute, 934.093. So it was founded in law. Adelson also moves this court to determine the confidentiality of records filed in this court, including the petition and appendix. Adelson, however, fails to demonstrate that anything in the records satisfies a condition that would establish confidentiality under Florida rule of general practice and judicial administration. Thus, her motions to determine confidentiality are also denied. So, and I believe if I remember this correctly, not Georgia, but what is her? Sarah Dugan said that there was a taint team so they themselves, the prosecution, had not seen everything because it did involve attorney-client communications, and obviously they didn't want to blow up their whole case. So there was another team that looked at it so that confidentiality remained in place. So there's somebody like standing in the gap between what Donna and her attorneys discussed and what was revealed to the prosecution that was disclosed, that came about through these wiretaps, through these legal wiretaps, right? So there's someone in the middle that looked at it and said, okay, this is not confidential. You can see this. This is confidential. You can't see this, but it'll be filed. So it sounds like she's challenging that. So it was sent to all of these guys and the attorney general. Oh, wait, there was a list somewhere that I wanted to show. There's 2 other people that comprise, 2 other justices that comprise this panel. This is not it though. Oh, here, I skipped over it. Roe and Bill Bray concur. So that all three of them, there was not, you know how sometimes you see it and it's like one did not and it'll put on their dissent. There was no dissension here. They all agreed. So then, was Donna satisfied, you ask? Was Donna okay with this? No! She's just a girl who can't say no or who can't accept no. So then she filed another motion. This one is interesting. So I've done a lot of highlighting on here. I'm going to try to just break it down as a lot of legalese. You know what I like to do, just break it down into plain speak so we can understand what's going on. Most of us know what we've seen, and I'm just going to tie it all together. Okay, let's get into it. Yeah, that's better. Okay, so on the 27th, the District Court of Appeal for the First District, this was recently unsealed, I believe. And so this is the one I want to talk to you about. So motion for rehearing and motion for rehearing en banc. So en banc is French for on the bench. And like I mentioned, there were 3 people in the appellate court who responded and concurred, right, to deny her motion. This request is for the entire panel, which I think is, or not a panel, the whole bench of the appellate judges, which I think is 12. Don't quote me on that. Whatever the number is, they want them all to look at it. So comes now the appellant Donna Adelson by and through the undersigned counsel. Blah, blah, blah. Rehearing is necessary. Respectfully moves for rehearing and or rehearing en banc. So a rehearing would be just the panel again and or, which I would think it would be or. Like, why would you do the rehearing with just the panel and then also en banc? But I'm not a lawyer. Rehearing is necessary because the panel decision, the decision clearly overlooked or misapprehended a key fact and the main reason behind the objective fear that Mrs. Adelson has when rendering this decision. I don't know that it's the appellate court's job to alleviate fear, but let's get into it. I don't like the wording clearly overlooked and misapprehended because it feels like they're finding fault. Not that they were confused, but that they don't know how to do their job and they misunderstood and overlooked a key fact. So I know there's a Socratic method with law, but I don't know, like, this is how you talk to someone when you're asking for a favor. Maybe it's not considered a favor, it's their legal right. But do you know what I mean? You're still, like, I would think, trying to curry favor. So specifically, the decision focused purely on one aspect of Mrs. Adelson's amended motion to disqualify the Honorable Judge Stephen Everett and neglects the actual harm or fear of future harm caused by that aspect. So they don't have any evidence of actual harm from that. You'll see as we go. And the fear of future harm, fear could be unfounded. We know she's off her Xannies. Do you know what I mean? She could just be scared. I would be scared too facing LWAP. But I wouldn't be involved with murdering people. Don't do crimes. So rehearing en banc is necessary because the instant case, as well as the issues within Mrs. Adelson's petition, are of exceptional importance that requires the consideration of a majority of the judges within this court. I do project management as a profession, and it's always like the running joke every time you get to a new project, all of the clients, because it's all internal, there is always like they're special, it's exceptional, like they're different than the others, and you get into it. It's just that they need hand holding, really. And I think, like, is this of exceptional importance? TBD, y'all tell me. The current decision overlooks critical Constitution implications. So they're saying this decision is far-reaching, right? That will have far-reaching consequences. So it's not just about her fear, it's about all of the future defendants and what they will face if this is not immediately remedied for this defendant. So they're saying for criminal defendants statewide and promotes or inadvertently condones, we don't know what you're doing. Maybe on accident you're condoning it. If not, then you're promoting this behavior. that erode public trust in the justice system and undermine the fundamental protections guaranteed by the state and federal constitution. So you are not violating, they didn't go so you are undermining her fundamental protections, and it could impact others. So procedural history, 3 count indictment is what she's charged with: murder in the first degree, conspiracy to commit in the first degree, and solicitation to commit in the first degree. So even though she did not pull the trigger, she's still accountable for the first degree. The conspiracy is because she paid someone to commit in the first degree. And the third one is the solicitation. Before she paid them, she had to holler, "Hey, you, come here, big boy." So if convicted as charged, Mrs. Adelson is facing a mandatory life sentence. And as we all know, in Florida, life is life. There is no parole as of 1983. So she is facing LWOP, life without the possibility of parole. So on April 7th, the state disclosed and counsel took possession of a flash drive that contained, and that's April of 2025, that contained numerous pieces of discovery, which will be discussed in more detail. So again, that was the first time they were hearing of it, but we'll find out. They didn't get their warrant until, the first warrant until December of 2024. So it was, 5 months later? Thereafter, counsel made several concerning discoveries associated with the discovery items provided. Discoveries from the discovery. Well, it seems like that worked out. That led counsel to file a motion to disqualify Judge Everett on Friday, April 11th. So that was the 11th. They got it on the 7th. So 4 days later, they were so alarmed. They were like, this judge has got to go. On Monday, the 14th, the trial court entered an order denying. So I'm going to read this in order as it is presented here, but it seems like these are flip-flop because normally you go in chronological order. They filed the motion on April 11th, and then on April 11th, after the motion was finalized, but prior to filing it with the trial court, the state disclosed additional discovery that ultimately led counsel to file a second motion to disqualify on April 14th. So I'm not sure because they said it wasn't filed yet. So why was it a second motion? Why couldn't they just fix what they were going to file? But I'm not a lawyer. So then on April 14th at 8:38, the trial court entered an order denying defendant's motion to disqualify. That's what we read first, finding it was legally insufficient. And he said no more. Protect the record. Don't blather on for little tidbits for them to kind of pick up like a squirrel looking for a nut and then trying to blow that into something, right? Just, it was insufficient. So on April 16th, the trial court entered an order denying defendant's amended motion to disqualify. So we just saw on the other one, it was April 14th that it said order denying defendant's amended motion to disqualify. So listen, something is wonky in there because we just saw the other day. Let me just go back really fast so you can see it again. This was filed on 4/15. Order denying defendant's amended motion to disqualify. Done and ordered on Tuesday, April 15th. So maybe it is the second one. You guys let me know what you think. But it definitely was not on April 16th either way, because we just saw it was signed on the 15th and it said order denying defendant's amended motion to disqualify. Either way, it could be a clerical error or it could just be my misunderstanding. Anything is possible. So on April 23rd, Adelson filed a petition for writ of prohibition with this court, seeking to have the ruling on her second motion to disqualify overturned. So we just read the response, right, from the panel. On May 9th, the Honorable Judge Long, that was the person who penned it, joined by the Honorable Judges Rowe and Bilbray, denied her petition, finding that the claims within her petition were meritless and facially insufficient. So now they are without merit. We are adding adjectives, descriptives, not just facially insufficient, which I think Judge Everett said legally insufficient. Yeah, he did. He said legally insufficient. They're saying on its face, it's insufficient, right? Judges sign these types of things ex parte all the time. In support of that holding, so they need to go be above and beyond, as Sarah Bone would say, to with specificity as to why this would fall out of the status quo ex parte warrant. In support of that holding, the court made several key findings concerning the allegations set forth by Mrs. Adelson. And this is written by Team Adelson. Motion for rehearing. Counsel submits with the utmost respect that this court has overlooked or misapprehended a key fact. And the main reason behind the objective fear, is it objective? We don't know why, that Mrs. Adelson has when rendering this decision at issue. As a result, a rehearing is required. The current decision summarizes the underlying facts offered by Mrs. Adelson, which were the basis for the motions to disqualify Judge Everett below. However, in doing so, the decision fails to engage with the central argument raised by Mrs. Adelson. Maybe because it was moot? I don't know. Anyway, the summary provided by the court is as follows. Adelson argues the trial judge should have recused himself based on her amended motion to disqualify. Why? She claims that the trial judge engaged in improper ex parte communications with the state by reviewing search and seizure. Well, let's get to the improper part. What's improper about this time that they did an ex parte warrant application, which is done every day? The warrant applications involved Adelson's husband's phone records and a wiretap of his cell phone. Okay, what's improper? Adelson claims that because the warrants relate in part to her and her criminal prosecution, the judge's review of these warrant applications constituted nobody's disputing that it's ex parte communication. You weren't there. The state's investigator was there and the judge was there. Clear ex parte, but okay, we were establishing foundation. So that has given her a reasonable fear that she will not receive a fair and impartial trial. These claims are meritless and facially insufficient. We deny the petition and right to explain why. Okay, wait a minute. I just want to make sure they are, yeah, this is the petitioner. Okay, so they're repeating, because I'm like, wait, how can you deny? They're repeating it because the way that it's structured, you see these larger margins, indentations. This is, the summary of the court. Sorry, guys. Okay, so it is routine for trial judges to review warrant applications and then preside over the resulting criminal trials. Trial judges also commonly issue arrest and search warrants, so they're repeating what was said in the prior one. They're using this to say that, to demonstrate that they didn't consider her fears. So the decision provides a thorough analysis about 1, the general prohibition on ex parte, so yes, and 2, the authorization provided by law concerning the judicial review of warrant applications. 3, how those 2 legal concepts expressly authorize the communications that took place in Mrs. Adelson's case. So what is an ex parte? What are the exceptions? How those 2 meet to authorize what took place in this case. Undersigned counsel is aware of and agrees with the legal analysis. Okay. However, the instant motion is being filed because the decision falls short by failing to recognize that the ex parte communication in this case do not fall within the recognized legal authority noted. Well, do tell. How is that? How does it fall outside of it? So a simple ex parte communication between law enforcement and a judge for a warrant is not what transpired in Mrs. Adelson's case. Well, what did transpire? We want to know. Here, at the time of the ex parte communications, the case against Mrs. Adelson had been pending for over a year. Okay. Was set for trial and hearing on pending motions were yet to be heard. Okay. So they can't ask for warrants if it's been pending for a year. If it's set for trial, if there are motions pending, it can't ask. I think here they're laying the foundation for their continuance ask, because all of that, I don't know what bearing that has on how that's abnormal. Does that never happen? Does it rarely happen? Is this the first time it's happened? So without any notice to the defense, which is what ex parte is, without the other party, X on the other party, new, very serious allegations based on false information. So I've highlighted that because I want to hear what the false information is. They're laying breadcrumbs, right? You're stating something, but there's no foundation established for that. What was the false information? Were relayed to Judge Everett and then were clearly considered at the time of ruling on the pending motion. Specifically, okay, we're going to get to some specificity, it sounds like. Judge Everett considered the false information. Oh, it's the false. What is the false information specifically? I thought we were getting there. At the hearing on the motion set to bond, had counsel for Mrs. Adelson been aware of the knowledge that the trial court had gained in those ex parte communications, the defense would have been able to argue against those false allegations with the confidential informant. So I think we all see the underlying issue here, right? It's ex parte because they don't want to tell you what they're doing. They need to get these warrants in place to verify what they have a hypothesis. They think this is what is going on. They have evidence to support that hypothesis to the point that they get to move from what is it on the Monopoly board? Yeah, it's the go. They're sitting on go. They roll the dice. The judge said, okay, and they got to move from go, right? They will get to move from go. If you have Mrs. Adelson's counsel in there going, oh, that confidential informant is a liar, you can't get that, we can never verify the hypothesis. Imagine the shenanigans that would go on if that was the way the law worked, right? So they're claiming they would provide the court proof of the confidential informant's lengthy criminal history, which included numerous felony convictions and crimes involving dishonesty, and ensure that no further harm came from the allegations. No, because if it makes it to court, then you put the confidential informant on the stand to verify what happened, and then you can talk about their criminal history. I mean, she met this person in jail. It's not like, they were an upstanding citizen. Y'all's two potential criminals together. But it also is giving vibes of the Adelson privilege, where Charlie was like, oh, there's a dead gangster in my driveway. Who are they going to believe? The oral surgeon, which he technically is not. Well, he's nothing now. Or the gangster, which the gangster, if he's dead, is dead men tell no tales. But do you know what I mean? Like, right? So here is Adelson, who is presumed innocent, has no convictions, but some very serious charges. So she's the upstanding citizen, and her counsel would have proved, this person is dishonest. Now, is this, I wonder, one of the same persons that Donna was rushing back in January, February, to get a deposition from, because they were a drug addict and might not show up or not even a deposition. They wanted to get testimony on the record because they might not show up. Now I'm wondering, is it because you offered them money and they wanted to get that money right quick? So you wanted them to testify and not do a deposition so that it could be that it would be the record. Perhaps. So the issue here is not whether the office of the state attorney or members of law enforcement are permitted to have ex parte communications with the judge. Okay, so we're all in agreement that that is a normal thing, right? That the state attorney's office and law enforcement can have conversations with the judge without the defense present. Okay, so what is the problem? The timing in which those communications were had. So are we back to there's motions pending, there's a trial date set, she's been in there for over a year in jail? Is that the timing we're talking about? Well, why? On what legal grounds? What statute? What precedence has been set that says that timing is not appropriate or that impacts the ex parte parameters? More importantly, it is about the impact that those communications had on the trial court. Okay, so it's not just the timing, it's the timing and the impact. Where's the case law when ruling on issues directly related to the very matters in which the court had learned ex parte? So no case law, no footnote to case law. We're just saying stuff. Proof of such, we're going to get to proof, is contained within the face of the record, including the mention, but they already said that on its face it had no merit. So now it's on the face of the record. Well, clearly nobody saw it. So please clarify for us. Well, not nobody, the 3 panel members. Including the mention in the order denying Mrs. Adelson's bond that trial court was aware that Mrs. Adelson was spending plenty of time with current counsel to prepare for trial. And you're saying he got that from the ex parte motion? That's not the exclusive reason he denied her bond, though. She's a flight risk. Jail is hard. Suck it up, Buttercup. This information was relayed to Judge Everett during the ex parte communications with the very investigator in Mrs. Adelson's case, who will ultimately testify against her at trial, which will be presided over by Judge Everett. So I don't know how they're tying that together, that's the only way he could have gotten that information. Perhaps one of the council members said, we're spending time with her, but we can't hear her and her tiny ear canal. You know what I mean? Like, unless it's in the findings or in the audio, I don't know. Like, did they present all of the visitation records? We can't see that because I've pulled Donna's visitation records and she only has that one person affiliated. There's a religious affiliation, but that was like last year. It doesn't show like publicly. It's not part of like a public records request of when her counsel visits. So I can't tell, but I did look. There's absolutely nothing in the record about the amount of time that Mrs. Adelson has spent speaking to counsel on the phone about her case, or the amount of time or number of visits that Mrs. Adelson had with counsel at the Leon County Jail. I disagree. I remember them saying that they were coming. It's hard to get an appointment. I remember Jackie saying, and she's an officer of the court, how of the many times that she did talk to her, Donna was having trouble hearing and she had to put a blanket over her head and someone was standing with her. There were things entered on the record by her counsel about the amount of time. I don't know with how much specificity as far as like a quantity. We spent 20 hours, we spent 40 hours, but she definitely stated they were spending time with her because they were clear. Like, just because we want to talk to her in a quiet place outside of the jail, which is part of why they were asking for bond, we still are meeting with her, but we're having these struggles. So I'm going to disagree with that. If you guys remember it differently, let me know in the comments. Let's talk about it. Even without the record evidence of the interaction and the resulting impact of such, so they're saying notwithstanding, what if that's not true? He didn't see that. The fact that one party was able to have unfettered access to the presiding judge on a pending case. So I underline that because where are they getting that information, right? They're saying there's nothing on the record about how much time they spent with the defendant. Where is it on the record that they had unfettered access? Like, usually there's an appointment, there's a hearing, this ex parte hearing, it's time bound. Unfettered means unfettered, like up, just free reign. Holler, call me at night, midnight, Mrs. Everett or mine. So we can talk about this. So on a pending case, provided them with information that was clearly intended to create a bias. Was it clearly intended? The judge can't be impartial? Because I seem to remember in Charlie's case, there was a story from Charlie that he was extorted, and there was a story from the state that he was conspiring. Those were not the same stories. Now, granted, it wasn't ex parte, but they were conflicting stories. And he seemed to be just fine. I mean, I haven't read Charlie's appeal notes, but did he feel like the judge was not impartial because they had different stories? So I don't know that it clearly, to a judge, would create a bias against the other party without providing the other party with an opportunity to be heard. So there's the fallacy in my argument because both parties were heard. However, I feel like the judge could be biased. He has to take what they're saying at face value, because especially in this case, if it's true, people's lives could be at risk, right? We will get there, but they're accusing Harvey and Donna of talking on the phone while the lawyers are visiting Donna, and they're talking on the lawyer's phone, so it's not monitored. So they could be planning a hit and nobody in the criminal justice system knows about it. So therefore they can't protect anybody, right? There's a reason why these calls are monitored. There's a reason why these rules are in place. And if they're circumventing it with the help of her attorneys, no less, that's a problem. We would want to know that. And I don't think you would want to call them in and ask them about it so they could stop the behavior, because there's 2 warrants that were issued. One was they were trying to figure out like what exactly was going on. They had a suspicion, right? So they had like a lesser warrant I'll explain it when we get there more fully, but they had a lesser warrant, and then they had that for less than 30 days. Based on what came out of that lesser warrant, they were able to escalate to the trap and trace, right? Which gave them more definitive answers, but they couldn't have got that trap and trace. I mean, I'm late reporting this. I'm sure you've heard it all over the internet. Those are the trap and trace are some of the hardest warrants to get. So they had to have a sufficient basis to get it. I don't know why. Like, I think a stronger argument would be to argue the trap and trace and get that removed if you really feel like the foundational warrant was suspect. Not get rid of the judge. Try to get that evidence out. I mean, maybe they'll get there, but in my layperson's opinion, that would be the stronger strike. So the error with the current decision is that it does not contain a single hint of considering this critical distinguishing facts, maybe these critical distinguishing facts, and whether those facts would have provided a facially sufficient reason to seek disqualification in this case. I just don't get that he would be biased, because in order to get, like I said, the more stringent guidelines are in place for that stricter warrant, there had to be something in that first one. They're not addressing that. So I don't know what this hint of considering. I don't see how it ties together. I'm not an appellate judge or a legal person at all. Ironically, the very law cited by this court in the current decision requires disqualification of Judge Everett, because if the communication was authorized as found, then there would have been no reason not to notify the defense and provide them with an opportunity to be heard. Yes, there would have, because if they had notified you of the trap and trace, you would have changed your behavior. And the trap and trace allowed them to determine the location of the phone when it was communicating with Harvey's phone, and the location was in the jail. So that, and the location of the attorney's phone. So presumably they were in a room with Donna, which can be checked by the logs. The judiciary can see, right? I can't see it. The public can't see it, but they can see when counsel came. So if it's at the same time that they're visiting Donna, that phone is communicating with Harvey's phone, and they tell you that, you're going to stop doing it. Like, that is just common sense. Yet neither the trial court nor the communicating party, the state, ever notified the defense of the ex parte communication in violation of the law. What law? So they're saying see Code of Judicial Conduct. So that's related to Everett. But where's the law that the state's got to tell you? On that basis alone, Ms. Adelson cannot receive a fair trial under the authority of Judge Everett. That's a huge leap, saying that he cannot be impartial. And I don't see how they're connecting it. It's almost like they're slighting the integrity of Judge Everett. I'm going to say almost. I'm not going to say they went after it, but they're hinting, based on this information he has, there's no way his brain can be impartial. If it's not true, it doesn't matter. Like, we need to see what was found. In addition, because again, it's a thesis, it's a theory that they're trying to prove out, and they need this next step to prove it out. Is every theory always proved out? No. Sometimes it's like, oh, that was just a coincidence. maybe one of the attorneys was stepping out of the room and calling Harvey to ask him a question and then go back in, something to that effect. Is that wise? No. But is it illegal? Probably not. They could have written down the questions and then later gone and asked Harvey when they were away from Donna to move any appearance of impropriety, right? Never put yourself in a position to have your integrity questioned. One of my mentors told me. And so, but why would even that still is facilitating an unmonitored conversation if they're ferreting information from Donna to Harvey without monitoring. But maybe it was innocent. Maybe there's an explanation. Love to hear it. The other overlooked fact is how damaging the false allegations were. Well, what are the false allegations? This can only be a fact if there are indeed false allegations. We haven't established the foundation yet for this to be a fact. We need to know first that they were false, that were learned during the communication. So I'm guessing that's the ex parte communication. The law at issue clearly states that when a motion to disqualify is filed, the question of whether the allegations are facially sufficient requires the court to accept the alleged facts as true. So this I underline on purpose because it says accept the facts alleged, because we're going to see in the wording from the state, the word they used is it does not make it a fact. And in law, the words matter. As true, and to consider them from the viewpoint of the movement. See McKenzie v. Super Kids, right? So that movement is the state in this case. But they don't allege them as facts. So with that principle in mind, the most critical facts that support the request for disqualification are as follows. On December 19th, the chief investigator presented an application for warrant, requesting communication records and an affidavit. We'll go down here. So they're saying the affidavit presented to Judge Everett in support of the application includes the following allegation, italicized and bolded with no factual basis. So we have this indentation here again. So they're pulling up verbatim what was in the other document. At this time, Harvey Adelson is the most frequent caller for Donna Adelson. That is true. I have the call logs. But it is apparent. And so I went to good old Webster's. What was the definition of apparent? Seeming real or true, but not necessarily so. So if they're saying apparent, they are not saying it is factual, because by definition, apparent is seeming real or true, but not necessarily so. Facts are facts. They don't seem real or true. They are actually what happened. Donna relays information to Harvey through attorney privilege. These calls are not monitored. So the apparent is their thesis. This is the theory that they have in asking for this warrant. Cellular phones have played a critical role in this investigation. Oh my goodness, through the whole Dan Markel murder. As the investigation proceeds, location of cellular devices as well as communication patterns become relevant. The cellular phone number for Harvey Adelson during this entire investigation, and the one he still communicates with Donna, so it's in his possession and control, pre and post wire. This order is being requested to determine any patterns with privilege calls that cannot be monitored, as well as any other potential threats that may be orchestrated. Emphasis added by Donna. So it says to determine. Again, they have a theory of something that is apparent, that seems real or true. They have this theory. So they're asking for this to determine any patterns to help confirm that theory, right? On the 9th of January, the chief investigator again appeared. So less than a month later, because that first one was December 19th. He was before the judge. 9th of January, they have this data that they've collected to test out their theory of the pattern. He comes back. He asked for a warrant authorizing the installation and use of both a PIN register with enhanced caller ID and trap and trace device, as well as an affidavit. Based on the application and affidavit, January 10th, the next day, judge signed the warrant, make it happen. And then it was applied to Harvey Adelson's cellular phone. In the affidavit, the state alleged that a jailhouse informant alleged Mrs. Adelson was offering to pay for witness testimony. So is this perhaps one of the witnesses that they wanted to get testimony on before the trial because they were a flight risk, they might be homeless, all these excuses they gave? Right? Because if they get the testimony, they can go ahead and pay them. If her trial keeps getting pushed out, that person's not getting paid. The more, hypothetically, the more they wait, the more likely the chance of this person running off and not coming back. But will that person, do they need to give them money now if they don't? You know what I mean? All of those logistics. And we know Harvey and Donna are cheap. That's part of how they got busted. They only bought one-way tickets to Vietnam by way of Dubai. Phone records for Harvey were reviewed along with jail phone call records and dates and times for attorney visits. There are overlapping communication, and then again, it's indented, so we're quoting, records between Harvey Adelson, the defense attorney's cell phone, and attorney visit. So if they have the actual records, this is now fact. They're not alleging it as fact. They have the records. They see there's overlapping. Could still be a coincidence, but they have established the pattern they were looking for. It was also learned that Harvey Adelson has switched carriers from AT&T to Verizon since the issuance of the previous order. I find that curious because what we learned from Lori's trial, her brother Alex had Verizon, and you can get the call detail even if you don't have a warrant for that phone. So that is interesting as a side note. As with the December 19th affidavit, the undersigned counsel has already determined factual assertions made in the January 9th affidavit. So what were the factual assertions? Because here they have the evidence because they have the taps, right? From December to January. So I'm not sure what they mean by that. They don't detail. According the memorandum of this investigation offered by the state assistant, oh my God, why can't I remember that? State's Attorney's Office chief investigator, the wiretap was terminated on February 24th, a little over a month is when they collected this data. Significantly, the memorandum document that neither Harvey Adelson nor the undersigned counsel engaged in any behavior with the potential witness which justified the overreach by the state approved by the court. He may not have engaged with the potential witness, but that's not the only thing they were looking for. They were looking to see if he was communicating with Donna on an unmonitored phone. They don't address that. The amended motion to disqualify also included that the application and probable cause affidavit submitted in furtherance of the Title III wiretap, that's the one that's hard to get, they had the first one to lay the foundation to support this, contains allegations which the undersigned counsel have determined to be false. Okay, well, tell us how you determined it to be false. The false allegations within the warrant applications are also key to the court's analysis because it was Judge Everett's consideration of that language that led to this petition. So because it's an elevated criteria for this tap and trace, they're saying that was based on false allegations. But what are the false allegations? Specifically, the warrant application presented a factual scenario that falsely suggested. How can a suggestion be false? They're saying this is a possibility. This is our theory. Mrs. Adelson and her attorneys were using privileged visitation and privileged communication to coordinate illegal acts. But we're going to find that out based on the outcome of the warrants. So it suggested that, but then what did it prove out? What did the actual captured data prove out? It either proved they were right or disproved that their theory was off, right? There's only two options. Well, I guess it could be ambiguous and then you need more detail. So we'll say 3 to be fair. Then you would ask for more information or more time. Coordinate illegal acts involving witnesses that could be called at Mrs. Adelson's trial. And they could have later used it to impeach that witness. Like maybe if it is ambiguous, they put the witness on the stand, that person lies, and then you pull out these documents. Hey, which is why they've turned it over to the defense now. They've captured what they needed to capture, which if the defense has it, are they still arguing that it's false? It sounds like they are. So are you saying that it was fruitless? And if it's fruitless, where does the bias come in? If it shows like fruitless as in the state was wrong, how is there bias? If nothing wrong happened, where's the bias? The application clearly sought to pierce the confidential veil of attorney-client privilege. Again, there was a team, so I just think this is like no legs. It went one step further and presented false information to help corroborate the falsities. No, if it said apparent, it didn't say it was truth. Specifically, the application alleged that the jail phone calls, as well as the dates and times for attorney visits, overlapped and suggested that two attorneys in good standing, and of course they're in good standing, they wouldn't be in front of the Honorable Judge Everett if they shouldn't be, were planning to present false information on Mrs. Adelson's behalf. And in fact, you may have. We don't know, because we're now questioning, these witnesses that had to be on record testifying early, or potentially tamper with witnesses, all of which have proven to be false. So now we have a footnote. I'm going to go to the footnote, because how has it proven to be false? And if in fact it has proven to be false, where's the bias? Not only have certain allegations involving both Mrs. Adelson and the defense been proven false, but the actual supporting records that were offered to support these claims were also proven false. Where? And if it's proven false, isn't this moot? Isn't it impossible for him to be biased about something that ain't true? Such as visitation records and phone logs. I hope they enter those in. I have the phone logs. I think I have them through April, but this is the period that they're talking about. I'll dig those. I'll do them in a separate video because this one is already getting long. But we'll talk about it. Furthermore, the mere suggestion proposed by the application concerning Mrs. Adelson and her, I'm going to scroll, sorry guys, communications with counsel are not only reckless, but deeply offensive and undermines the integrity of the proceedings entirely. So they're in their feelings. They're offended that they were accused of being involved. Nobody is beyond reproach. Nobody. Therefore, all the legal principles cited in the current decision is legally correct. It does not accurately address what transpired. So they're saying, yes, you have legal standing for that, but you're forgetting about these other things, about our feelings being hurt and about us being excluded, all that. Moreover, it does not consider the damaging false information provided. Not false information. They said that it appeared. It was apparent, provided, or the impact that said information has had or could have in the future on Mrs. Adelson's case. If it's false, I don't understand. Like, that's my big question mark. How? The current decision's failure. I mean, isn't that an insult to Everett? Like, you heard something that was wrong and you can't forget about it because it's wrong. You're going to hold it against her, the wrong information. How does that make sense? The current decision's failure, it's like they're saying it's true, because that's the only way he might be biased, is if he knows that they're up to shenanigans. But if in that case, shouldn't the attorneys recuse themselves? If you guys are really, if it's been proven that you guys are really, isn't that a conflict? Because they'd be called to testify. This is wonky to me. The current decision's failure to consider these critical portions of this issue must be remedied through a rehearing. So maybe they'll get the rehearing, but I don't know that they'll get him recused. So as discussed with the current decision, ex parte communications are prohibited except for a few narrow exceptions. One of these exceptions being the presentation of sworn applicants for warrant. So this fits. This practice is one that will continue in future cases as it is necessary. It is a necessary feature of our legal system. However, allowing the current decision to stand presents a loophole. I don't agree. That invites abuse without firm boundaries and accountability. Because who isn't going to say, oh, they lied to get that warrant? Do you know what I mean? Like, especially if there's damning information found. If nothing was found, who cares? Let the man sit. The danger is that actors who seek to manipulate the judicial process, now they're calling the prosecution manipulators. They were mad that they were offended that they were accused. But now they're calling the prosecutors liars and manipulators, right? They're creating a loophole. They're following what the law says, but they're creating a loophole that could forever change the playing field for defendants in Florida going forward. And that is a danger. It will be exploited. It will exploit exceptions to the prohibition on ex parte communications as a backdoor to improperly influence the court. The only thing that they've put in here that suggests he was influenced is that it wasn't on the record how many hours they spent. And is that an improper influence? Did they not mention it? The current decision suggests that said improper influence, if sought legally and with authorization, is okay and will not provide a legitimate basis to seek disqualification. The panel's decision is if allowed to stand, continues to uphold the harmful precedent that allows this unconstitutional and shocking behavior. Let's do the blow up tall face. As a result, the undersigned asked that this case be reheard en banc, and then that was sent all their Florida bar just to validate they're in good standing. No, it's required. I don't get it. Wherefore, the petitioner by and through undersigned counsel asks that this court grant the instant motion for rehearing. I keep wanting to say rehearing, or alternatively grant the motion for rehearing en banc. So either the panel hear it again or the entire bench of appellate. Okay, hold on. Grant the motion for rehearing en banc and allow a majority of the judges within this court consider the matter as it involves an issue of exceptional importance. Please hold. I'm recording early in the morning, so he's awake now. So let me know what you think. I feel like they're grasping at straws. Like they're trying to have their cake and eat it too. Either it was factual, and then that would create a potential bias, assuming that Judge Everett doesn't have the wherewithal to continue to be impartial as he has done in all other cases, or it's not factual and then it's moot. What is the bias? Do you know? Let me know your thoughts on it, and let me know, just let me know what you think. I find it interesting. This is a defendant, obviously, with a lot of money, so they're going to do everything they can. But I don't know why they're highlighting that Harvey is now, well, maybe because it's public now, not sealed, they want to say, like, it's false, therefore Harvey was not doing it. But I think Harvey's next. What y'all think? Let me know down below. Okay, you want to say goodbye? You want to say toodles? Toodles. You have your morning voice on. Papa. Okay. It's your birthday. Happy birthday. Wow. Oh, okay. Gotta go. Talk to you guys in the comments. Bye.